Hello, welcome to the webinar on the topic Legal Aspects of Open Access to Data in Public Sector. My name is George Krivokapic, and today with me I have my colleague Jelena Adamovic. We are both lawyers with specific interest in intersection of law and technology. We particularly deal with the issues of online freedom of expression, information privacy, digital security, and access to knowledge. This presentation today will have 6 parts, and we will try to explain following topics. At the beginning, we'll talk about general open data concept. Then we'll continue with similarities and differences between open data and freedom of information moments, and continue into the right to open data, right to request data for reuse. Then we'll talk about European legal framework. Namely, we'll mainly focus on public sector Information Directive and its revision from 2013. We'll then focus on open data portals as such and their regulation, and finish with the issues of implementation of open data in Serbia. Namely, open data concept is related to 3 things in general, but these things can be expanded in different directions. First, there is idea that we should understand what's going on in a government and have transparency of governments and public bodies. Secondly, open data concept has a high influence on development of e-governance and efficiency of public administration in digital age. At the end, there is like high commercial and non-commercial potential that certain public data bears. So these 3 directions are related mainly to use of data which can be opened by the government. So to enhance transparency, further develop e-governance, and have a high reuse potential of certain data in both commercial and non-commercial environment. This idea is based on the fact that public bodies are funded by the public. So they should act in the interest of the public, and therefore public has the right to know and have access to data collected and held by public, except in some justified exceptions. So generally, as you can see, state has a high potential to collect a lot of different type of data. And on this picture, you can see just some of the sectors where government and public administration are the main data holders. So in all these sectors, there are probably no other institution, especially in private sector, which can compete with the amount of data. And this data can be used in different styles by different institutions and has to be open because they are paid with public money. So this process of creating an added value is shown on this picture, and practically public administration has to share some data sets online, then a community of developers and private corporations has to find appropriate data which can they use, and then develop a different kind of products. These products can be mobile apps, can be some kind of databases, and so on. And eventually these products can be offered to final consumers, citizens, and businesses benefiting from these applications which are created in this process. What is important to understand that within the essence of open data concept are open formats. So when we talk about transparency, we talk about the general access to information, but when we talk about open data, we're not talking about transparency, we're talking about the data in certain formats which can be reusable. So having PDF will not help us much if we want to reuse data. But like, as you can see on this graph, as the data are put in more, in better information quality program from a technical perspective, these formats can help us to analyze, process the data and analyze on a higher level. So having open formats is some kind of prerequisite for open data concept. So there are some similarities and differences between open data movement and freedom of information movement. Freedom of information movement is mainly ideologically driven. It emerged long before digital age with the main goal to make governments more transparent and work in public interest. So it's the idea to make some kind of symmetry between information held by government and citizens and civil society. So we understand what is really going on. On the other hand, open data movement is more technology driven. It focuses on the idea that public data in open e-formats can be very useful for private purposes, commercial as well as non-commercial, that they can drive innovation and lead to economic growth and benefits. So these transparency-driven and technology-driven approaches have some differences, and the concept of open data goes more into the commercial idea that data can create new value which can be used by the society and the market. Exemptions are something where we can see big differences between freedom of information and open data regulations. And we just listed which exemptions exist to the access based on freedom of information regulation. On the left side, you can see that threats to life, health and security, criminal proceeding, defense of the country, public economic interest, state official or business secret, and protection of personal data can be a reason to exempt the access to information. On the other hand, and I would just like to notify that these exemptions are general exemptions which can be found in different freedom of information laws in Serbia and in the region, and they can vary because that there is no strict EU level regulation on this matter. On the other hand, when we talk about open data exemptions and data which can't be accessed and reused, the list is a bit longer, and in addition to the exemptions on the left side, there are also some other exceptions like data outside of the public task of institution which has the data. There are some exclusive IP rights on the data. There are logos, crests, and insignia. Data are coming from public service broadcaster or educational and research establishment except university libraries, or cultural establishment other than libraries, museums, and archives. Why these exceptions for open data are broader? Because there are institutions in a system which have to base their business model on use of data, and if these data are completely free to use by anyone else, they can't do their work properly. So we can discuss more this issue of exemptions in relation to open data, but for the moment we'll continue. Another difference is that open data can sometimes be provided under certain conditions, while freedom of information requests which are allowed provide data without any further conditions. So these conditions are usually in the form of licenses which are listed on this table, and when you are provided with the data, you have to comply with the license which is attached to this data. As you can see, there can be different licenses which determine domain, attribution, and share-alike issues related to the data and the content which is provided based on open data. So, in general, there are thinkers and activists who think that we need one anonymous movement on right to data, who think that we should regulate all these issues, both freedom of information and open data together, and there are like good arguments for that. However, at this moment, especially on European level, there is no clear unification of freedom of information rights, but there is a clear unification related to reuse of public sector information, or as we call it, open data. So these two different approaches cannot be merged together at the moment, but hopefully sometimes in the future that will be possible. At the end, before we enter into the legal regulation part, I'll just show that like public data in open formats can be reached by the private sector and interested parties in two different manners. First, there is a possibility for proactive publishing. Public bodies publish data proactively, even in those particular sets of data are not asked by anyone in advance. So practically, that's the idea of open data portals, where different public institutions provide access to their databases permanently and immediately by anyone who is interested, without submitting any particular request and without entering into the rights of the person who requests that data. On the other hand, if data are not proactively published, there is possibility by any interested party to submit requests for reuse of open data. So practically anyone is entitled to approach the public body and submit a request to receive particular set of data in open format, and then that set of data can be given only to such individual. In this situation, there is possible to involve exemptions which were clarified before. So at this stage, we'll start talking about the right to open data, and I will provide a microphone to my colleague Jelena Adamovic, attorney at law and expert on open data regulation.
Hello, everyone. So what will we now step into is this world of European legislation, because this actually topic has been regulated on European Union level only as of, let's say, recently, only after the actually beginning of the century. So what is the situation now? As George already mentioned, at the moment there is no EU harmonization as regards Freedom of Information Act. That means that the level of legislation on which member states are currently isn't sufficient to make some EU directive or similar legal instrument that would harmonize these laws. There are two exceptions for this. What was possible until this moment was that European bodies actually make regulation that concerns their information, and now we have regulation regarding public access to documents of European Parliament, Council and Commission, but these rules apply only to these three European Union bodies and not to the documents that are held by public bodies in member states. That is one exception, and the other one is that what was possible until this moment was to make harmonization regarding the data concerning environment. That is because it is regarded that environmental data are so important for public that access to them cannot be left freely to member states to decide are they going to grant it or not. and for this reason, on EU level, we have harmonization on this like specific aspect. So on all the other issues, there is no unified system of freedom to information of European member states' public data. However, on the other hand, what was possible as of 13 years ago was to make some kind of regulation that concerns only this second aspect of open data, or in other words, it was possible to make some rules regarding submitting of the request to get the data for reuse. Actually, what happened in 2003 was that first directive on reuse was issued, and at that moment, that directive actually did not aim to make some binding rules, but it actually took the approach that member states are free to decide are they going to grant to their citizens the right to submit reuse requests. But what directive said, if you are going to grant your citizens right to reuse data, these are the rules how you are going to behave. So that was in 2003, 13 years ago, and that system was applicable for the following 10 years. But because the development of the digital age actually is very speeding up, it actually goes very fast. What was obvious very soon after 2003 is that those minimum standards that were made on the European Union level are simply outdated, and that it is not enough to leave to member states that decision, are they going to allow reuse of data upon individual requests. What became necessary is to make this mandatory, which means that all the member states as of 2013 had to impose this obligation. So what actually was done in that decade is that the European Commission actually started these revision procedures. During the revision, actually, what was evident is that level of development of open data is different in different member states, and that actually this situation is not good for businesses in Europe, because it actually is in direct danger to the single market of the European Union. So they revised the directive in 2013 and actually made mandatory for all the member states that they have to actually accept these reuse requests from their citizens in accordance with the minimum standards that were regulated in the text of the directive itself. So actually the Commission on its own website actually explained why these changes were necessary and why they had to be made in such a short, let's say, period of time as of 2003 and 2013. So what the Commission actually said is that what the directive needs to focus on is the economic aspect of reuse of information rather than on access to citizens to information. Actually, what the Commission explained is what George already actually was saying in the beginning of this presentation, and that is that these data that are to be gained based on the reuse request actually are a driving force for the economy of the European Union, and this is the reason why this regulation had to be done this way. Actually, it indirectly encourages member states to make as much information available for reuse as possible, because actually only if the member states themselves actually do that, then the aims of the directive can be achieved. The directive had a couple of other improvements in its text when compared to 2003 text. It widened its scope. Firstly, it now covers the behavior of all the public bodies in member states on all levels: federal public bodies, regional, municipal level, regardless of the form of the public body, which means ministries, agencies, and so on. and it also covered only in 2013 content held by museums, libraries and archives, which were excluded from the scope of 2003 directive. But actually, because this open data topic is now actually gaining its popularity, and because it gains for economy are evident, what was possible at the moment when the directive was revised was to include also these, let's say, this kind of public bodies that come from education and cultural sectors. What was also the main benefit of the changes that were made in 2003 was actually this concept that open data, actually data given to citizens for use, in order to fully be used by the private entities, had to be actually, let's say, free in terms of costs they produce for the interested parties. So what the 2030 directive did is actually it proclaimed that principle is that all data that are given to public upon reuse request have to be free, and if something is to be charged to the interested party, then that should be only on the level of the marginal costs that the public body had in procedure for collecting of those data. And another thing that was actually the consequence of all these changes is that 2013 directive made now machine readable formats a norm, which actually means that in the future all the public data, when collected and kept by the public bodies, the idea is that it should be done in those open formats. So this is in very brief terms what is actually current legislation at the European Union level regarding open data. As you can see, it only covers this aspect where individuals and public and private entities actually approach the public body and ask for specific set of data. What is not still possible at the European Union level is this proactive actually aspect. So because proactive aspect of the open data practically means that member states would be obliged to publish certain sets of data on some regular basis. There is still not enough common ground in all member states what should be the minimum of this obligation, so there is actually no harmonization of EU laws. What the Public Sector Information Directive did is that it only actually included one provision in its text that encourages member states to open proactively data, to make open data portals, to make those open data portals easily searchable, to make them cross-linguistic searches possible, and all that comes within that actually this movement of opening of data that should be, let's say, future. So in the future, the more the member states and actually generally governments around the world start proactively publishing data, that should mean practically that the number of the individual requests for reuse of data shouldn't be less than over time. And that is the whole idea of open data. So the consequence of lack of harmonization of laws regarding proactive publishing of data is that on European Union level there are no common rules regarding the manner in which data should be published in open formats. But what is happening and what is visible not only in Europe but worldwide
Okay, sorry for technical problem with this webinar, but now we are continuing from the page and open.
Regarding open data portal, open data portal, again, because we are currently talking about legislation on the European level, are not currently regulated, which means that European states can freely decide are they going to have open data portal and how will that data portal look like. However, what is happening at the moment is that there is this actually promotion of open data throughout Europe, and that European Union is helping this movement. It does so in two manners. At the moment, there is European Union Open Data Portal. That is the portal where citizens or any interested parties can approach European Union information in open data portals on one side, and on the other side, the European Union also funded European Data Portal, and that is the portal that actually harvests metadata from public sector portals throughout Europe. Actually, on one place you can find the data that are to be found on any government data portal of any European member states. So instead of going to the portal of, for example, France or Italy, you can simply go to European Data Portal and get all the information you need on that one place. So that is what is happening on the European Union level. But because open data topic is not only European specific, it is something that is ongoing worldwide. What is also happening in the recent years, because of the popularity of open data worldwide, we have also worldwide portals. By simple Google search, you can actually find a couple of portals that harvest metadata from all around the globe, depending on the specific topic that you're interested in. And all this actually should be a proof that open data have real value and that the benefit that they can bring to general public, and that can also overlap to the public bodies that collected the data, is something that that is significant and that should be promoted.
So the last part of the presentation will be dedicated to implementation of open data concept in Serbia. So we'll talk about the current situation and ongoing processes in that respect. Firstly, it is important to emphasize that open data concept at this moment is not recognized as such in Serbian legislation. So practically, what does it mean is that you can use freedom of information request to get some materials and maybe data from public sector, that there is no right to open data as such, and that there is some proactive opening of public data by some institutions, but that is still, let's say, on low level. In order to be successful to obtain data from public institutions through freedom of information requests, it is at the moment important to understand the infrastructure of particular public sector institution, to understand what kind of database do they have, what kind of data they have, and how they can extract this data out of it. Asking these particular, preparing freedom of information requests based on these particular facts can help you to get some data sets, but there is no full legal certainty that you will get it. On the other side, there is a community in Serbia which is looking for regulation of open data, and which is, let's say, hungry for data from public sector in order to reuse it. These driving forces can be grouped around three different communities. First one is general public administration community, which will like to exchange data in these open formats. Then there is an academic community who would like to use this data in academic research, and there is a commercial community, let's say private sector community, which can use data in order to do both research and develop new products. The need for open data is recognized in Serbian strategy for development of e-government in period of 2015 to 2018, and there is also a need to implement a public sector information directive in the process of accession to the EU. So these two things from a strategic level are also helping moving these issues forward in some sense. In that respect, there was also establishment of working group of open data, which contains experts and interested parties from both public sector and private sector. And this group is established with the task to promote open data with all relevant stakeholders, as well as to make proposal on the manner in which open data right to reuse of information should be regulated in Serbian laws. Some of the members are representatives of public institutions who already started opening their data. Other are civil society using this data for transparency purposes. The third one are representatives of private sector interested in further reuse of such data. So there is like a good atmosphere in the group, and we are all together working on these implementation practices. So in that respect, we did deep research on implementation of public sector information directive within the EU member countries, and we try to estimate what is the best solution for implementation of open data concept in Serbia. Jana will talk a bit more about the results of this comparative research.
In short, all the member states of European Union where public sector directive was adopted were at different level of development of open data, and of course all of them had their national laws and national legal systems that had their specifics. But when we actually make the summary of all these manners in which they implemented the directive, you can roughly find a couple of let's say ways in which this was done. We might say that the most common approach was to adopt reuse law that regulates only this matter, which means that you actually make a new law in your legal system that regulates only the topic of reuse of data and the manner in which citizens can submit requests for use, in which manner it has to be processed, in which deadline the public body has to respond, and so on. And that is like the subject of only this sector-specific law. The other very common approach was that member states that already had in place their freedom of information laws actually decided to insert into that law provisions that would regulate only reuse, which means that in one Freedom of Information Act, you have rules that are applicable to freedom of information requests and reuse requests. And when it comes to reuse, then they implemented the rules that can be found in the directive itself. What was also to be seen in the national legislation of the member states is that certain member states actually took the approach when they were changing sector-specific regulations. For example, if there was a law that was dealing with urban planning or urbanism, and the state wanted to actually open some data from these sectors, then it would change actually the laws that were sector-specific in order to include these new rules that deal with reuse requests. And also depending on their internal systems, if there is a federal state that has like this, like federal governments and local governments. What was also evident, which is the case of Austria, for example, they amended on the federal level their federal laws, but then all these local regulations were also changed in order to be in conformity with the minimum requirements of the PIC directive.
So, based on all these experiences by other countries, we try to figure out what is the best way to implement public sector information directive into the Serbian legislation, and we came to the strategy which includes changes on two laws, in fact. First, implementation of right to open data as a part of freedom of information laws, in a sense that current law will be possibly updated in the next month, so there is a possibility that this right will be included in it. The rationale behind this strategy is that involving a new right to reuse data in public sector as within the separate regulation would be problematic for implementation because Serbian public institutions already have problems with within this implementation phase. So freedom of information law is very well known by public institutions, and if it is expanded in this manner, there is like a bigger chance that institutions will follow in implementation phase. The second reason for such a strategy is that most of the rules regarding the process of accessing the data through the request, which are applicable to freedom of information requests, will be also applicable to these open data requests. The downsider of this approach is that some actors think that this change could undermine the effects of freedom of information law and maybe reduce access rights to current freedom of information requests, but that can be sorted out through clear exemptions to open data requests, which are wider than exemptions which are possible to freedom of information requests. Regarding open data portal rules, there is an option to implement regulation in their respect, not within the freedom of information law, but within the new e-government law. So practically, there is a need and a strategic understanding that open data portals should be regulated on a national level through the regulation in the form of law, and that this regulation should provide opportunity to institutions to proactively open data, but estimation of the current state of public administration in Serbia that not all the institutions would be in position to proactively open data. So this approach will be then involve open data portals on voluntary basis, and then an option for government and the ministry to provide mandatory rules for certain institutions to proactively open data through open data portals. So practically this is the end of our presentation. We have a lot of research in this area, and if you need any more information, you can send us email on my email, which is krivokapic@gmail or krivokpic@gmail.com, and we'll be happy to return any questions. So thank you very much, and thank you for your attention.